My name is Clint Negley. I'm with UC Davis Innovation Access, which is the tech transfer office for the UC Davis campus. This is part of the Intellectual Property and Technology Transfer series. This is the fourth of 6 presentations in this series, and the topic of this presentation is, who is an inventor? So this presentation concerns inventions, it concerns patents, it concerns inventors named on patents. It's an important consideration. It's not well understood. It has historical basis in the Constitution, which refers to patents being rewarded to inventors. So for that reason and other reasons, it's important that inventorship be properly determined. So that determination necessarily is determining who made the invention, not the invention in a broad sense, but who made the claimed invention. Or to say it in another way, the inventor is one who makes the claimed invention. It's a bit circular. It doesn't answer the question or even suggest the process. There's the need to focus on the specific words here and understand what they mean. The word invention obviously is key, but the term claimed invention is actually the focus, and the verb is all important. Who made the invention? Who makes the invention? So to determine who an inventor is, we need to understand each of these terms. So an invention, it's defined in the patent laws as an invention or discovery, which is not very helpful. An invention is actually something that's new. It's a product or a method. Product could be a composition or a mixture, a compound. A method could be a making method or a using method. But not all inventions are patentable. So the analysis goes to the claimed invention. What will be the invention that's actually patentable, the invention that's actually claimed in the patent application? So that's the frame of reference. And who's the inventor? It's the one who makes that claimed invention. So making is the act of inventing. But what is making? And under the law, making, strictly speaking, is conceiving the invention. It's the one responsible for the conception of the invention or the conception of the idea. But that needs refining. So let's dig into that further. Conception is an intellectual act. So it's intellectual contribution by a person that's actually the basis of inventorship. Simply put, an inventor is one who makes an intellectual contribution to the claimed invention. By contrast, one who reduces the invention to practice without actually making an intellectual contribution is not a legal inventor. Under the law, a pair of hands, in quotes, is not deemed to be an inventor unless that person made an intellectual contribution. So, an example in the university setting, if the professor makes an idea, makes an invention, has a concept, writes out the full protocol, the full recipe for how that invention can be made and used, and then that protocol is carried out by someone else, postdoc, a grad student, a technician, patent application is filed, there's only one inventor. It's the professor, even if the professor actually did none of the work. That's the nature of the legal requirement for inventorship. So that other person who did all the work was the person who reduced it to practice, who showed proof of principle, who made the physical embodiment. So it doesn't really seem right that that person is not named as an inventor. Strictly speaking, this is the rule, but the reality is it's a very rare situation where one person completely thinks through, plans out, and expresses the invention in full enabling detail. The reality is that usually the reduction to practice includes some intellectual contribution to actually figure out a way to make the invention and to implement it. So usually that person at the lab bench or who otherwise is making the prototype is a legal inventor as well. So a few other aspects of this that are important and often not well understood. Right at the top of the list, inventorship is not the same as authorship. And this leads to much confusion. A paper is written, there are 10 names on it, all those people have contributed, they're all authors, they all want to be inventors. Under the law, it doesn't necessarily follow. An inventor is someone who makes an intellectual contribution, so there's need for analysis, name by name. And it's important that it be done properly. If inventorship is not properly assigned, then the validity of the patent could be undermined. The patent could be attacked on this basis, in particular in the U.S. Necessarily, it's an imprecise determination. It leads to discussions. It leads to debates. It can lead to disputes, but that's the nature of the law of inventorship. It needs to be handled properly in each instance. And the consequences are very important. Ownership typically flows from inventorship. Typically, the employer owns inventions made by the employees. So knowing who invents leads directly into who owns. And in the university context, and certain other contexts, there is often a royalty sharing arrangement between the university and the inventor. So again, getting the names of the inventors correct is very important. Lab notebooks can provide an important record of this. One more reason to have good housekeeping for inventions. In short summary, an inventor is one who makes an intellectual contribution to an invention as it is claimed in a patent application. Thank you.